I'd like to thank our sponsors. First of all, I'd like to thank Rise Recovery for hosting us today in this beautiful space. I'd also like to thank Methodist Healthcare Ministries. They're supporting our series this year, as well as a new initiative and new funders, Beyond Funding, which is the group that Kronkosky Foundation, United Way, and San Antonio Area Foundation are funding for purposes like this to help support nonprofits through the times that we all are going through. So we appreciate that. And because of that, as I said, we are recording the session to have these up on our website.
Okay, Dave, everyone thinks AI is going to take over. I just don't think that's going to happen. We're about 10 years away from that. Well, everywhere I go, we are always having technical difficulties, but that's okay. So as I entered, earlier, or actually yesterday when the panelists were talking, and Katie and I, we had a nonprofit that really went through some massive changes earlier this year because of the executive orders that are coming out of DC, cancellation of funding, cancellation of contracts that would affect swaths of employees, hundreds and hundreds of employees. And I told her, and it felt like we're drinking out of a fire hose, and it felt like COVID again. Because during COVID, we were having to deal with those. We're working 15, 16-hour days and trying to help organizations get through all of this unprecedented times, which we are in again, because I can understand some of the cuts that were coming, but I never thought some of these other nonprofits that, give meals to senior citizens or help children, that they would also get funding cut. I don't think anyone saw that coming. So we know that y'all are having to deal with very difficult times right now with that loss of funding, and groceries still are very high. People do not have as much money to give anymore. And so we know that's difficult, and we're so sorry that we're having to do this and give you this information. But nevertheless, we're in those times right now, and hopefully we can help you and also give you some alternatives to laying people off. Kendall had some great ideas, and some of this is going to overlap, but like I said, I'm going to talk about the legal aspect, and she's going to talk about the human aspect, and then Susan will also add what her experiences were, which are amazing, of how she dealt with things from a human perspective. So, why are you doing a reduction in force or a layoff? You're going through some cancellation of federal or state funding, cancellation of contracts. You're trying to save costs. There's a lack of work. There's a lack of donors, money coming in, or you're just trying to consolidate, and this is the time to kind of try to make yourself more efficient and see where you need to make cuts, or it's all of the above. That's why you're having to consider layoffs. So what are the things that before you do that, what are the questions that you're going to have to ask yourselves? And the questions like, how long is this going to last? Is this permanent? Is this temporary? Are these employees that, or maybe you have cancellation, but you may get another funding source where you're going to be able to bring back some of these employees, and how do you do that? Kendall and Susan will talk more about that part, but these are questions that you have to ask when you're trying to make those decisions on how to decide what kind of a RIF you're going to have. And then there's alternatives to RIFs in terms of, or some of these are in step. And during COVID, many of my organizations, we did a variety of these. One is, I always do a hiring freeze. It does not make sense, and it's not even good optics, that if you're laying off 10, 20, 50 employees, and then you're hiring at the same time. Now, there are some circumstances where you're allowed to do that, but if, for the most part, to me, you should have some sort of a hiring freeze if you're really seriously considering a layoff. Reducing overtime, reducing work schedules, reducing benefits. Of course, those are really, really difficult, but those are the things that we look at first before we would consider any other kind of layoff. Then the other things that you can look at before you do a layoff is a furlough, which is a type of layoff, but it's with the expectation that a majority of the workforce is going to be coming in and or coming back, and that's something that you could do. A lot of times you do the furloughs it's going to be a reduction in hours, they're not going to have any hours, they can go apply for unemployment. I know that's difficult in the nonprofit sector because then you have to calculate that. But a furlough is a way of doing a RIF with the expectation that some of these people are going to come back if you get any kind of alternative funding source. Early retire or voluntary separation, that's a lot of times my organizations will do a two-step. They will ask people to voluntarily separate for a severance or an enhanced benefit or an early retirement incentive, and then whoever doesn't self-select, then you can go to the involuntary terminations. But a lot of times you can take care of your, cost issue with some people that are self-selecting because they want to retire early or they want to get a small severance and then go on to the next thing. Temporary shutdown, that's in some cases organizations will have to do, and we saw that during COVID, but a lot of times PPP was able to get everybody back up and running. So you need a plan. Anytime that you're going to do any type of a layoff, even if it's a layoff of two, hopefully not one, you have to have a plan. That's the best way to be able to execute what you need in order to downsize the company for survival. So I always make sure to review the company policies with respect to how you pay out severance, if there's a severance policy, how you pay out PTO, any of those things, how you have to provide notice for termination or anything like that. Always look at contracts for executives. If you have any executives or managers that are under a contract, even if it's a small, simple contract, make sure that we're not violating anything in the contract if you are having to lay off any of your executives and managers. And usually there's one or two that you're going to be having to lay off, and so that's always important. How many of y'all are unionized? Is there anyone that's unionized? Thank goodness. There's not a lot of unions here in San Antonio, but there are some. There's even some nonprofits that are unionized. And this is just, if you ever go to a unionized workplace, you're going to be ahead of the curve. There's something called a collective bargaining agreement. That will always have additional information, and it will, a lot of times the well-done CBAs will have information with respect to how you conduct a layoff or reduction in force. And so you always need to make sure that you're reviewing that so that you're not violating that. Also, get yourself a really good union attorney. I am not one, but I know one. And so it's just always important. But I'm not going to go too much into the union stuff since none of y'all have a union. Make sure to document a business justification for the layoff. This is going to help you in your communication, and the communication to the employees, the communication to the board, the communication to everyone internally as to why you are doing this. For example, the one that we did earlier, it was because there was 2 huge contracts that were canceled. And it was very clear, and that's why we told them that this is, we have these cancellation of contracts that affect hundreds of employees, and unfortunately we're having to lay off because that contract will likely not be renewed. It's been canceled, and even when there's a renewal process, it's not going to be renewed. And that's really simple. Now, other times it is economic considerations. Though, anything where you're doing a business justification, I would run it by the lawyers if you have one. Susan brought up something great yesterday. She said, some of these nonprofits can't afford lawyers, which I totally get. Get yourself a lawyer on the board. Not too many, but get one. Get one that's either an employment lawyer or who knows an employment lawyer. Katie is great. She's on a couple boards. I've been on boards as well. But that is a great way to get free legal advice where you're not having, something like this. Having a lawyer to help you with the RIF, it's not that much. It's probably a few hours. Now, there are some cases where some organizations need a lot more help because of capacity, but having me review the severance agreements for an hour and charge you $500, that will save you hundreds of thousands of dollars is worth it. Okay. In some cases, I'll do it half an hour. Establish the selection criteria for selecting employees. Kendall's really going to go through this because she, I give the advice, but people like Kendall actually execute it. So she's gonna give some more detail about this, but things that you can look at are seniority. Temp part-time employees are usually the first to go. Last in, first out. Yesterday I had that first in, first out, and Kendall corrected me, it's last in, first out. Skill sets, you know, what kind of particular skills that y'all are needing in a reorganization to continue, performance levels, and if they're assigned to contracts or grants that have been cut. You know, obviously those employees likely will go first. Initial planning, so who's going to be making the decisions? I think it's really important that you have managers and supervisors. I'm a little bit jaded, managers and supervisors that you would like to be deposed or that would make a good witness at trial. Someone who is able to treat things confidentially. Someone who is, I've had a client where they had a lower level supervisor making these decisions, did an Excel spreadsheet and made comments on it like, well, even though he has more safety violations, he has a family. And so we're not gonna get rid of him because he has a family. And write it out in Excel. The E in Excel is exhibit, the E in email is exhibit. You know, make sure that you have people that have common sense that are not gonna be writing these out where a good plaintiff's attorney will discover it and put it up, and obviously we're settling those cases before it gets to that point. Make sure HR is involved. Make sure someone like Kendall is involved at all aspects. The lawyers you can get away with just reviewing some contracts, but I think that the best well-executed RIFs are the ones where you have HR involved at every detail. Also, have a small team that is looking at this and reviewing this, someone from your executive team, someone from operations, and we always have to have a finance person who is helping us run the numbers as to who's going to be selected, how much money this is going to cost. I work really closely with a lot of the CFOs and that are amazing, they're amazing. I am not a math person, but it is incredible. Even if you have a well-done RIF where you have money for severance, not everyone does, but how much it costs. And also if you're going to be providing severance agreements, how much that is going to cost. If you're going to be providing COBRA, paying COBRA premiums for a couple of months, how much that's going to cost. And we have to make sure that we're working with them so that they are ready with paychecks and ready with whatever information is needed. So I always make sure that you're working with someone in accounting or your CFO. Legal, obviously, and then making sure that the members on your team are someone that you can trust and that will maintain confidentiality, because it's a very difficult thing. I've been involved in RIFs where people on the legal team that I work with or the HR people are on the list, and it's a really difficult time. But you have to have people on your team that maintain confidentiality, because if you have people who are leaking the information to their best friend who's also leaking it to their best friend, it just it can make it difficult because the rumor mill starts going and you're having to triage before you've even communicated anything. Okay, so voluntary programs. I do like these. I do think that they are for larger employers, but in some cases it may help, especially if you have a larger nonprofit, if you have 100 employees or more, that or even 50 or more, that you can have a voluntary separation. And typically what that does, it does decrease, it doesn't eliminate, but it does decrease age claims, because basically they're self-selecting to leave early or to retire early. Some are not retiring, they're just leaving early, and you just provide them severance that is anything above and beyond what they would be entitled to. And so you can't always control who exits, but you can limit it to certain functions and groups. For example, that you're only going to have it at the executive level, or you're only going to have it at the managerial level, or even, only the executive assistants, something like that. You can control that, because what happens is that if you were to open it up to the entire organization, there may be people that you do not want to leave, right? And so that what we've done in the past is limited to certain functions or groups, so that we're not having people who we really want to stay and continue, and that we have the money for them, that they're not going to self-select, that they're going to stay. Still have to comply with waiver obligations that we'll talk about in a second. And then early retirement programs are similar, but you're just offering enhanced retirement benefits. And when you have an older workforce, if you have an older executive or managerial section, that is a good way to entice them to retire early, because you can't force older people to retire. You cannot force them to do that. Right, Scott? You cannot force it. And, but you can offer some incentive packages in order for them to do that. Usually we see this in larger companies, but I just want y'all to be aware of it. And then you get to the involuntary reductions, and this is what we call layoffs or RIFs. You're going to have more control over the selection. There is more risk to it. The way you mitigate it is through severance agreements. You have to make sure that they're objective, measurable, bias-free, and they are quicker to implement. I mean, you can put the list together. If you have a smaller workforce, usually you would have someone in HR and maybe some managers or executives who are making the decisions. In larger places, we would go to the managers and ask them, who on your team would we need to select? The downsides to it, of course, are there's potential discrimination lawsuits, more liability, there can be adverse publicity, damage to employee morale, failure to retain key and good employees, sabotage from employees who are kind of leaving out the door, cutting too deeply could be an issue, and then remaining an attractive employer if you're going to be continuing. Those are all difficult things that you have to look at, but sometimes you just have to deal with it because you don't have the contract anymore, you don't have the grant funding anymore, or your donations have shrunk. And so to me, I think you just have to take the downsides, but we're going to talk about how do you mitigate these downsides and in order to protect the organization so that you continue. One thing that I would recommend to everyone, I'm sure you've heard this, make sure you have employment practice liability insurance if you can afford it. Ask your broker. In some cases, it's not that much more than your general liability insurance. And I have been on boards where they have no idea. They do have it. They just checked all the boxes, and they have no idea. They're so worried. They're worried that we're going to get all these lawsuits. And I'm like, do y'all have employment practice liability insurance? And sure enough, we look and we do. And so it makes you, kind of breathe a little bit easier and rest at night knowing that if you may get some claims, that's always a potential. But if you have that employment practice liability insurance, it sure does help, alleviate some of that pain that can come with lawsuits. So what are the best practices? Kendall's really going to go through this and how she actually does it. I can give all the advice in the world, and then I kind of sit back, and HR has to implement it, or the executives have to implement it. But these are kind of some of the things that in kind of the best executed RIFs, these are the things that I do. We select the job categories and positions for reduction after we have the people who are going to be the decision makers. We have the unbiased business-related criteria for selection. We create a list of employees. We apply the criteria to the group, which is easier said than done. And then we evaluate whether there's any protected class that's more impacted than any other group. We call it a disparate impact analysis. If you need to hire an attorney, hire me to do that. It doesn't take very long. There's a little free software. I could also send y'all the link to do this. And basically it's just saying, are y'all, in our selection, are we selecting more minorities than the majority? And in some cases, you have a majority workforce, maybe that's all Hispanic female, or you have all white female, or all white males, whatever it is, and no matter what kind of cuts you make, there's going to be a disparate impact. And it can be okay to have that as long as you have a business justification and you have support for the people that you are letting go. Sometimes you do have a disparate impact. There's just nothing you can do because of the makeup of the employees. But I would always just, look to see who is being selected, if there's anybody where it looks like it's targeting or any way, and make sure to go back to your managers if they've been making the selections to ask them for support as to why they've selected certain individuals. This is where you need HR. This is why I say you have to have HR for every kind of every level of a RIF, and that is to have an oversight and approval of the final list by HR and the executive team, and double check the selections. And I'll give you an example. I actually can give you about a dozen examples, and Kendall's laughing because she knows the same thing, is that we'll get a list, no one's really, they're kind of looking, but they're not double checking the spreadsheet. Someone is let go, and then they claim race discrimination or gender discrimination. And we look like, for example, I had one client, they had a woman that was let go out of a sales team. They said she was the lowest performer. When we actually go to the list, we don't even have to do that much digging. In some cases, it's in the Excel spreadsheet that they provided us, and it shows she had the better evaluations, she had more productivity than two men that stayed. And we don't even have to dig through anything. It's in the Excel spreadsheet that the manager gave us that selected the employees. And it's a prima facie case of gender discrimination, right? I have another, the one I told you where we had one gentleman had severe safety issues, the other gentleman had a technical safety issue, but the one that was let go, they said, well, he didn't have a family, so it doesn't really matter, and the other one had a family, and we wanted to protect him. That is just the jury, here in San Antonio, the jury is gonna award him hundreds of thousands of dollars. And so that's one of the issues that I see over and over again. But if you had HR who's looking and someone who's double checking, it really does help in trying to kind of squash or quell those kind of incidents, and push back, and make sure you have someone that's pushing back and not just automatically rubber stamping a list, that that there's careful consideration. Now, there are times where a company is willing to take a risk because of the employee, and maybe it's an employee you don't want there anymore, but at least that everybody knows, everyone understands the risk and knows the risk of that employee. But a lot of times, if you just have someone, especially HR, double checking and pushing back to make sure that there's support for the people who are selected, I think that alleviates a lot of issues. Develop a communication plan. This is, to me, out of probably 15 years of helping companies do RIFs, this is the one thing that I see companies do wrong, and that is communicating what is going to happen to employees. It is so important that you communicate, and communicate as human beings to people, because they're losing their jobs. Most people live paycheck to paycheck. It doesn't even matter how much you make. Most people live paycheck to paycheck, and they are one paycheck away from having to go to the food bank, get assistance. And that is really hard, at a human level, to tell someone that they're being let go, especially when it has nothing to do with performance and it's just a cut in funding or grants or a contract. So develop a communication plan. There's one CFO I work with, she says clarity is kindness. And I love that phrase. Clarity is kindness. Telling people what is going to happen alleviates a lot of the issues. It doesn't mean that it's going to alleviate every issue, but it will alleviate a lot of issues. Select who's going to deliver the message. Get someone like Kendall, who's been doing this for a long time and knows how to do it and do it well. The timing, we're going to talk about some timing issues. Having talking points, FAQs, having those done ahead of time for any kind of possible question that is going to be coming up. Having FAQs with resources, that's so important. To tell them what the unemployment number is, what the unemployment email address is, other resources that they can use. And I know Susan and Kendall are going to talk about how do you deliver this? Do you deliver it to a group? Do you deliver it to individuals? I will tell you what not to do. There is Not one of my clients. I would never have advised him to do this, but there was a company in town, a restaurant, that they, during COVID, sent out postcards terminating their employees. It made the news, it made all the news outlets, and that company did not really bounce back because of how they handled that, where even if you had to make the, all the a lot of restaurants closed, right? But there was a way to handle that, and where they could have come back. And to me, I think, letting people know, even if it was a manager at every restaurant, telling their workers, this is COVID, this is unprecedented time, or even just giving them a phone call before they got the postcard. I probably would have done a letter, not a postcard, but there's a way to do this, and there's a way not to do it. Draft warn letters if applicable, we'll talk about them in just a second, and then have legal compliant draft severance agreements. Now, we lawyers have been told for years that we're being replaced by AI, LegalZoom, all kinds of things. It hasn't happened yet because all of the forms that I see they're just not compliant, especially when you have to provide severance agreements to people who are over 40. And this is where I would get a lawyer involved, get one of your lawyers on a board, call me, hey Sonia, can you give me 30 minutes, review these to make sure that they're compliant? Because if your severance agreement is not compliant, it's void. So even if you have money to provide for severance and you pay it out and you don't get a release in exchange, to me, you might as well just be burning the money. Buy yourself some peace. Make sure that in order to pay out the severance, that you have to get a release of claims in a severance agreement. One of the things that I see that's a mistake that all organizations do is they have a severance policy that nobody has reviewed in years. And it says, we pay out severance for this amount for this many years. And they don't say that it's in exchange for a release of claims. And so if you try to get a severance agreement for the amount that you're providing in your severance policy, it's not going to be valid. You have to give them additional consideration, additional money in order for that release to be valid. So that's something for y'all to look at, go back, see if you have a severance policy. Frankly, you do not need a severance policy. Lots of people think you need one. You don't need one. Now, bigger organizations, that's kind of a benefit, but if you can't afford it, don't put it in your policy. And if you do, make sure that it's in exchange for a release, even if you're only doing 2 weeks. To me, it's worth it. So should you consider a severance in exchange for a waiver or release of all potential claims? The answer is yes. If you can afford it, if you can, and I know it's hard, especially if you're a nonprofit, but if you have a small budget of severance that you can pay out, the answer is always get a release in exchange for the money. Like we said, you have to have other consideration for a waiver or release of claims that's in addition to anything that they're already entitled to. What else can you offer to soften the blow of the layoff? Outplacement services. Sometimes in your, if you have a PEO that helps you, a professional employment organization that helps you, in the contract, they will give you discounts for outplacement services. And so it's something that you might want to consider doing if you have the budget. Payment of COBRA premiums, not contesting unemployment, paying accrued but unused PTO. A second policy for y'all to look at when y'all leave here is look at your PTO policy and see how is that written with respect to what you pay out if they are terminated. And if you know that you have a small budget, because whatever is in that policy in Texas is going to control. You don't have to pay it out in Texas. It's only if you have it in your policy. And if you don't do it according to your policy, they can have a wage claim against you under the Texas Payday Act. And they will go to the Texas Workforce Commission and they will file a claim. And that particular division is very, very aggressive. They want the employees to get paid what they're owed. So if you can't afford it, take that out. If you can afford it, make sure that it's written, properly, so that, or have a cap on it. That's where a lot of companies and nonprofits get in trouble, is there's no cap on it, and then you're having to lay them off and then pay out 100 hours of PTO. So if that's not something that you can afford, make sure to have a cap on it. So what do you have to have in releases and agreements in order for them to be compliant? They have to be voluntary. You have to give them adequate consideration, which we've talked about. It has to state that the employee is releasing all claims against the employer. One thing that's important is state the employee has received all wages due, that they acknowledge it, because you can't technically waive Fair Labor Standard Act claims under a severance that hasn't been negotiated or approved by a judge. And so, but one way to combat that is to state that the employee acknowledges that they have received all wages that are due to them. There's statutory requirements if they're over 40, and of course you can have a confidentiality provision. And there's been a flux from the National Labor Relations Board as to what can be in severance agreements, but that guidance that was kind of limiting what we could have in severance agreements with respect to non-disparagement and confidentiality, that's been rescinded by the current administration. Pitfalls, again, you can't waive FLSA claims for prospective claims, but have yourself an acknowledgement of wages. No rehire provisions is tricky. So typically when we've negotiated a settlement after a charge or a lawsuit, we'll put that we do not have to rehire the plaintiff or the employee. However, if you're laying people off for economic considerations, because there's funding cuts, it's presumably not because of performance issues or disciplinary issues or anything like that. So if you put a no rehire, then it does kind of put some shade on whether or not this was really for economic considerations. Typically, we probably wouldn't put no rehire provisions in severances related to a layoff. However, if you have an employee that is starting to negotiate that severance after they've been laid off, or they get an attorney and they say, no, I wasn't laid off because of economic considerations, it's because I took FMLA, it's because I made a complaint against my manager. That's really why, and you're negotiating a settlement. In those cases, you can put that no rehire in there if you're giving them additional consideration for release of that claim. There's special rules that to apply to waiving EEOC and state claims. It's boilerplate language that we would have. Workers' comp claims are not waivable. A RIF of one. I get this all the time. I get a question of, well, we're going to eliminate this position. Well, they really want to eliminate that employee. It's not just a position. And I'm like, if it's not really a RIF, then, I mean, it's fine if you're going to say eliminating a position, but it's not going to help you anymore, defend a lawsuit or defend a charge at the EEOC. So, to me, it's semantics. But if you have 2 or more employees that y'all are letting go, because y'all are having to do some cost cutting, then to me that can be a RIF. But one, to me, it's not going to help you any more or less. Comply with the Older Workers Benefit Protection Act regulations and guidance, which we're going to talk about right here. So the Age Discrimination in Employment Act and Older Workers Benefit Protection Act, they have additional release requirements. Anyone who is releasing a claim and is over 40, you have to have these in the waiver. And this is where most companies will trip up. They just don't comply with this. So I'm not going to go through all of them. The most important one is usually if you're terminating someone who's over 40 and you're giving them a settlement agreement or severance agreement, you have to give them 21 days to review. It's waivable. They can still sign it the same day. And then 7 days to revoke the agreement. That is not waivable. Do not, and the other thing that employers do is as soon as they sign it, they'll pay it. You can't do that. Don't pay it until after they usually I'll say with the next pay period or 14 days. But if you have a reduction in force, even if it's just 2 people, you have to give them 45 days to consider it. I always see this mistake. It's 45 days of a RIF, 21 days if it's 1 person. You also have to give, if they're in a RIF, you have to give the employees of more than 2 or 2 or more information regarding those being laid off. So this is one, even my largest employers sometimes will push back on this, but you have to give them a list of everyone who was considered If it was two, the county department and IT department that were considered, you have to give them the titles of who was considered and the ages of those considered and selected and those considered and not selected. You're a small organization, they're gonna figure it out, but by law, you have to provide it. If you do not provide it, it makes the age release void. And typically in RIFs, those are the types of claims. We always get an age claim. You're not getting rid of people for economic considerations, you're getting rid of the older people because they have more benefits and pay. And that's typically what the argument is. This only applies to a few of you. This is the Workers Adjustment, Retraining, and Notification Act. Employers with more than 100 or 100 and more employees have to provide 60 days written notice to employees before closing a facility for more than 6 months, or laying off 50 to 499 employees, where it's at least 33% of the employees' workforce, thinks about 150, laying off 500 or more employees at a single site. And I'm just providing this to y'all. It likely will only apply to a couple of y'all, but just so that y'all know and don't panic, because a lot of times we'll get the panic phone call and say, we didn't give 60 days notice and someone said we had to give 60 days notice. Only if you have at least 100 employees and then you meet these other thresholds does that have to apply. And this is who you would have to provide notice if it did apply, and then what the penalties are for noncompliance. And exceptions to this include unforeseeable business circumstances. COVID was one, cancellation of a contract, cancellation of grant funding would be another one, but I would try to provide as much notice as possible anyway. And some states have mini warrant acts, Texas does not, but if you have a remote employees in other states, it may apply, especially if you have one in California, God forbid. But I just want y'all to be aware of this just in case, or if you move to another organization where it would apply. Other considerations, making sure you make prompt payment of final wages 6 days from the date of termination. Typically, you only have to pay them on the next pay period if they resign or quit, but if you lay them off, it's an involuntary termination, you have to pay them within 6 days from the date of termination. Again, look out for other state laws. If you have a remote worker in California and you term them, you have to give them their last paycheck the same day. Reminder about non-disclosure and other restrictive covenants, return of company property, and of course, if you're unionized, which none of y'all are, the CBA would control on some of this. So I know that was a lot of information, but hopefully, I saw a lot of heads nodding that it's good information for y'all to have. And hopefully, if you're having to do one, even if it's on a small scale, knowing what you have to have and what you don't have to have, and then also get an attorney to look at something for 30 minutes or an hour. It'll save you a lot in the future. So with that, I'm going to turn it over to Kendall, who is amazing and who actually will execute these plans.